Ah. Oh, hey, OPT. Look at you finding the time of day.
Well, it's past 4:30, so my shift is technically over now.
Ah, I see. Well, then this is going to be a separate hangout, just you and me. How's that sound?
Okay.
That just means I get to harass you some more.
That's fine.
Okay, cool. So my first question to you is, what you think? What you think? What you think? Huh? Pretty cool, huh? What you think? Huh?
Oh, it's great.
Now, on a scale of 1 to totally fucking awesome, where are you at right now?
Oh, what's beyond totally fucking awesome?
Okay. Well, there's flaccid. There's a little bit excited. There's annoying. Then there's hard. Then there's rock hard. And then there's dude. I can cut diamonds right now.
Probably closer to that.
Okay, so you can cut diamonds right now. That's what I like to hear. That's what I like to hear. Okay, perfect.
Gosh, like if my client was in a case where the judge gave that order to the opposing party, I would just sit back and be like, "Wow, this is amazing!" Like, I can't even imagine what that was like for like his actual attorneys to see that and just be like, "Yep, that's what we thought."
All right, perfect. So
Jeez.
let's go over some of this with you because you're here, so why the fuck not? So what I'm going to do is I'm going to bring up the order. I'm going to screen share so we can bring this up. So let's do this. Okay. All right, OPT, you should see my screen.
There we go. Yes.
Okay, and what I'm going to do is I'm going to show the audience as well. So let me do that. Main showing. Perfect. All right, there we go. Let's hide that. Okay, so it says now pending. Before the court are plaintiff Stephen McRae, Mr. McRae, motion for order to show cause, ECF number 23. That's, again, just to be sure, that's electronic court filing?
Yeah.
Okay.
Yeah, my understanding, yeah. The feds have the same kind of a thing, so I'd have to assume that's what that means.
Okay, and for those of you who are in the chat, this is probably going to be a carbon copy of our last live stream, but fuck it, we're doing it anyway, because this is my channel and I do what I want.
Nice.
I mean, fair,
Yeah,
right?
no, fair, absolutely, 100%.
Perfect. And Kyle Russell Curtis, Mr. Curtis, revised motion to set aside default judgment, motion to set aside ECF number 20. A hearing on each of these motions would be appropriate prior to ruling. However, absent mutual consent, no hearing can be held until on or after June 1st, 2020, pursuant to orders of the Chief Justice of the North Carolina Supreme Court. So I'm guessing, now again, correct me if I'm wrong here. Absent mutual consent, that means they would both have to agree to show up, and the reason that is a thing is because of the current situation we find ourselves in.
Correct.
Okay, perfect. So, alright, we're good so far. The court further finds that it should not issue further ex parte relief beyond the partial judgment by default, the judgment it entered in this action on January 23rd, 2020, ECF number 17. So that means this is, we're only going to talk about the judgment by default and nothing else.
Something like that. Basically, yeah, it's saying like, look, we're going to have hearings on the rest of this because, we're not going to. I'm not going to rule on something ex parte, just one motion any further than what I've done already.
So the court is like, okay, I understand you brought me a lot of additional shit, okay? We'll get to all this shit, but in the meantime, because things are kind of fucking crazy right now, I have an order in place and I would really appreciate it if y'all bitches followed it.
Something like that, yeah. Yeah. That's about right.
That's about right. What I'm looking for here is the words "you are exactly right."
Oh, okay, you're exactly right.
Perfect. Can you say it again?
You are exactly right.
Can you say it slower?
You are exactly right.
Okay, anyway, the court further acknowledges Mr. McRae's report that Mr. Curtis has failed to comply with that judgment and has therefore requested that an order be issued to compel Mr. Curtis to appear and show cause why he should not be held in civil contempt pursuant to section whatever the fuck.
Yeah.
So, basically, there is a section, and go read it if you want.
Yeah, it's the North Carolina General Statutes. That's how they can hold you in contempt. Not a big thing.
Now, because nothing was being done for a very long time, because everything was on standby because of the current situation we find ourselves in, Mr. McRae, Steve McRae, submitted a supplemental affidavit. So, number 5 says, Mr. McRae supplemented his request by supplemental affidavit. This is ECF number 25, filed on March 27th, 2020, asserting that Mr. Curtis has failed to abide by the court's instruction in the judgment, including not turning over the Non Sequitur Show Twitter account, but instead deleting it. Yeah. Although, now there's this rumor, let's call it that, going around, that he resurrected that Twitter account and just changed the handle. So, not sure how that's going to impact things, but that's where we're at right now. I'm not sure how that's going to impact things, but that's what appears to be the case. Yeah, Kyle has resurrected the dead Twitter account and changed the handle. So, yeah.
I mean, if it still exists, then he's still in a position to turn it over, which is fine.
Yeah, exactly. So, Compliance Order 7, ECF number 18. So, ECF number 18, if I remember correctly, was from the court saying, look, this is what you have to do it. Yeah, moving on. Compliance Order 7, ECF number 18. Not turning over access to the Non Sequitur Discord server where Mr. Curtis contends he does not administer, a contention which Mr. McRae challenges in his affidavit. So the question I was asking you, this was when you completely dropped, is that if it is proven that Curtis does control the Discord server, can he get slammed for essentially lying to the judge?
Well, really depends on, like... So, let's, hypothetically speaking, say Kyle says, oh, you know what, I could do it, and here you go. The judge is not going to be happy, but he's not going to do much about it. If it can be shown that he has control over it, and he's still not turning it over, yeah, you're probably going to have some issues.
Yeah, because in the last Hangout, Boole said that this idea that Curtis does not control the Discord server is complete horseshit. Because it was because Kyle was giving Boole all these instructions on what to do with the Discord, because ultimately the power was in Curtis's hands on how the Discord was operated.
Right.
So
now, of course, obviously he could have ceded that to somebody else right before all this happened, or even heck now, which would be a problem for him. But he may not have that anymore. I don't know, but he might probably still does, but I have no idea.
Yeah, this is under the assumption that he does still have control over it, and Mr. Curtis is fucking lying about that. Again, underneath that assumption, but moving on.
Yeah.
Which Mr. McRae challenges in his affidavit, not turning over ownership of the YouTube channel, but instead stating that he intends to retain 50-50 ownership of the channel. Kyle, I don't think that's your decision to make. I mean, if I remember the judgment, it said that Steve McRae was the channel's rightful owner, not 50% owner. The channel belongs to Steve because Steve is the rightful owner of the channel. With with language that explicit, you would think, right?
I seemingly remember that line too, and I would think you wouldn't want to screw around with the court after court's told you that. I could be wrong.
Providing a list of inaccurate usernames and passwords for accounts associated with Non Sequitur, and failing to provide any financial documents. So we did see that what Kyle submitted was not bank statements or financial records, any legit financial records.
No.
What Kyle presented was a bunch of hearsay summaries.
Was it even that?
Well, that's how Steve's lawyer phrased it.
Okay, well that's fine then. Yeah, because I thought I'm like I remember being even less than that, but if that works.
Well, I would have phrased it a different way, but it wouldn't be proper when putting it in a legal document. I would say, listen, you have not given me any financial documents. You've given me complete bullshit. You literally pulled this shit out of your ass. What the fuck is this?
Right.
And while we're at it, what the fuck is wrong with you? That's what I would say, but
I mean,
whatever.
You want to know how many times I've wanted to put that in a legal filing?
I imagine a lot, right?
Many.
Oh,
Very
man.
many.
All right, so moving on to number 6. The purpose of civil contempt is to preserve the rights of private parties and to compel obedience to orders and decrees made for the benefit of such parties. And then it lists a citation right here, which I'm highlighting.
Yeah, it's a case citation.
Yeah, so a case citation right there. I'm not going to bother reading because it's it's Egyptian hieroglyphics to me.
It's the legal authority that line comes from. That's all it is.
All right. The court may initiate civil contempt proceedings upon a finding of probable cause. And it looks like there is another reference.
That's a statute and then a case that also talks about it. Looks like. Yeah.
All right.
So, yeah, that's a...
And then it actually continues right all the way to here. Wow.
Yeah, so we call that the Lexis citation, since the word Lexis is directly in it. That means that case wasn't actually published in any book anywhere, but is available online for you to find.
Oh, neato burrito.
Yeah, that's me being a nerd for a moment. Continue, please.
Okay. So it looks like this is in quotes here, so they're quoting from this citation here. Probable cause refers to those facts and circumstances within the judicial official's knowledge and of which he has reasonably trustworthy information which are sufficient to warrant a prudent man in believing that the alleged contemner is in civil contempt.
Yep.
So basically, yeah. Are you
a
guy?
Definition of... Go ahead.
Are you a guy whose critical faculties aren't completely fucked? Are you a guy who can tell the difference between his face and his ass? Are you a guy that thinks it is kind of weird to be sleeping naked on a beanbag eating Cheetos? Well, if you are that type of guy, then that means that I can tell you this information, and if you believe it. If you believe it's sufficient, then we're good, basically, right?
I mean, something like that. That's probable cause is also the standard that you have to have for like a police search warrant or something along those lines. Obviously, that definition is tailored closer to civil contempt, but the probable cause definition is pretty standard throughout everything. So yeah, it's not a high standard in any way, shape, or form, as you can see.
Basically,
basically
what we're saying is that if we had a reasonable and trustworthy man, critical faculties on order, and I gave him this information, the information would appear to that guy to be reasonable, trustworthy, and sufficient to warrant.
Yeah.
Perfect.
Yeah, like the prudent man is also called the reasonable man. So like basically, yeah, anyone of reasonable sound mind would understand this to be a thing.
Yes. All right, so basically, hey, look. Anyone who has their head screwed on straight would know that I have something here and it needs to be acted upon. Okay, perfect.
Basically, yep.
Proceedings for civil contempt may be commenced by the order of a judicial official directing the alleged contemner to appear at a specified reasonable time to show cause why he should not be held in civil contempt. Gives another reference.
Statute, yeah.
Yep. Such an order may be issued on the affidavit of one with an interest in enforcing the order and a finding by the presiding judicial official that there is probable cause to believe the alleged contemner should be held in contempt. And then another reference.
Yeah. So that also means, like, Steve obviously has a interest in enforcing the order, but that also could mean, like, if somebody else had some actual legal interest in enforcing this order for whatever reason. I can't think of one off the top of my head outside of, like, if Steve had a creditor of some kind or something like that. Like, the money that he got from non-sec, part of it's supposed to go to someplace else. There's a contract or something like that. Mm-hmm. Maybe that would be another person of interest in this lawsuit, but that there isn't that. It's just you put it that way because it's not just the plaintiff.
Got it. And once it is determined that probable cause exists, the burden shifts to the alleged contemner to show that he should not be held in contempt, that he lacks the means to comply, or that his non-compliance was not willful. So basically, so Kyle is standing in front of the judge, and the judge is going to be like, okay, I'm about to shove this gavel up your ass. Do you have a good reason why I shouldn't do that right now?
And it's
Were
on
you in a
him
fucking
to prove,
coma? Yeah. Were you in a fucking coma? Were you in an accident that made you forget this case was a thing? Like the fuck, bro?
Yeah, and that shifts the burden to him. So basically, now the court has sufficient information to believe that, for probable cause to say, hey, you could be in contempt. Come before me and show me why you shouldn't be.
Yeah. And what would be great is that while Kyle was giving his case, the judge is there going, while sharpening his axe. On one of those foot-powered grinding wheels.
Right. Stone with the sparks going.
Yeah, with the sparks going, and he has, like, welding goggles on.
It's like, oh no, please continue.
Please continue. I'm enjoying this. But this one guy who also hates Steve told me that this was a good idea, and Steve was being a meanie head poopy pants, and keep going.
I mean, God, whoever the hell he got advice from, I feel sorry for that person. Because that person is clearly not in reality.
So it looks like there is a what's the word I'm looking for? An excerpt, I guess.
So this is so we like to do so it's from another case, and after like a certain number of words in Ohio, the general rule is like 50. We do just what we call a block quotation. So that's what this is. It's just a quote from the Red Value Inc. case. It's just that it's really long, so we just put a block quote. So that's all it really is.
Well, because we like to be thorough. A court's only means of compelling compliance of a person found in civil contempt is imprisonment as long as the civil contempt continues. So this is something that was brought up in my original stream. So basically, he could be in prison for as long as he continues to act like a shithead, right?
Yeah. So, well, there is limitations on that to a certain point as far as, I mean, at least in Ohio. I don't know about North Carolina, because there comes a point where you can't necessarily hold somebody in prison indefinite or in jail indefinitely. But the difference between, and I'm going to go on a tangent real quick here, the difference between criminal contempt and civil contempt is this. Criminal contempt, you get thrown in jail for X number of days because of the bad thing you did, and you're just there. Like, outburst in court, you're in contempt, go to jail for 2 days or whatever. Civil contempt is when you have the keys to the jail just by doing the thing the court said to do. You can purge yourself of civil contempt by either, doing the thing, paying the thing, following the order. If you follow the order, the contempt is purged and it goes away.
Yeah, because on the very next line it says, subject to certain time limitations.
Yeah.
So I guess after those time limitations, the court would have to do something else to persuade Kyle to not be a shithead.
Something along those lines, yeah. I don't know what that is necessarily, but there does become a point where you just can't hold the guy in jail forever.
Yeah. And we don't know what that time period is, so
It's probably in statutes, but I'm not a North Carolina lawyer, and I'm not going to look it up.
no, don't even bother. It doesn't matter here.
Doesn't.
An order holding a party in civil contempt must specify how the party may purge themselves or herself of the contempt. Exactly what you said. And imprisonment must end once the person has purged himself or herself of contempt. Because civil contempt seeks to coerce compliance rather than to punish, the purge provision is essential to a civil contempt order.
Correct.
So basically it's like, listen, you're going to sit here and you're going to see how shitty it is to be here. You want out? Well, boy, have I got an offer for you.
Right. Like the easiest example of something like this in like what you would see in like even TV and whatnot is the witness that refuses to testify. And the judge will put you in contempt, will hold you in contempt, and you'll sit in jail until you decide to testify.
Damn. Now, of course, just like it says here, there are limitations to that, but
yeah, exactly.
That's essentially 100%. The gist of it. Like, oh, I see. You think I'm a fucking joke. You see this robe? You see this hair? You see this gavel? We're not fucking around here, boy.
Yeah.
All right. You see all this fucking shit? You see these fucking pews and this bench and this fucking building we're in? See that blindfolded lady over there holding the scales? Yeah, this is some real fucking shit. And to show you it's real fucking shit, you're gonna sit in jail until you acknowledge that this is real fucking shit.
Basically, yeah. It's like, yo, listen to me, seriously.
God, one person said that I would make a great judge. I just want to be like, bro,
Dude, seriously.
Seriously, dude. Let's not go that far.
Yeah.
Boy. I come up with some creative punishments, I'll tell you that much.
That would be a thing to see, for sure.
Your Honor, may I present to the court that it is unreasonable that the sentence be, hang on one second, let me read it, be hung up upside down by his testicles in the middle of Starkey Road and Ulmerton. And then I'll be like, I see no problem here. What's your point? God, that's fucking great. Anyway, okay, so number 8 is the big one. It says, materials of record and unrebutted affidavit testimony filed to date support a finding that there is probable cause that Mr. Curtis willfully violated the court's January 23rd, 2020 judgment, and specifically that he has failed to provide Mr. McRae with accounts associated with the Non Sequitur show, has failed to relinquish control of the associated YouTube channel, and has not timely produced the requested financial documents. So
I think that was about every point the judgment wanted him to do.
Yeah. So as a lawyer, and you know you're looking through your lawyer glasses, you know the thick bricks that they are. Does this tickle your cackles in a certain way?
That makes me feel happy. That's great. The courts have now found probable cause that a potential contempt has happened. Which, like, hey, we've made step 1. We've done it. This is step 1.
All right. So basically, this means that because there is probable cause, there now needs to be a hearing on it. Correct?
Correct.
All right. And that hearing, because of what's going on, again, the time frame, I assume, is a little bit fluid, but they did say a date here. Let me see. Was it like, what, June 1st or something? It was number 2. Yep, June 1st.
Yeah, June 1st, yeah.
June 1st.
Assuming it doesn't get extended out for whatever reason, but now, June 1st.
Yeah, and with the current situation that's going on, which we're not going to say because I don't want to be demonetized,
right.
It's it might shift, it might not. Who the fuck knows? Time will tell.
Basically, yeah.
Mr. Curtis has not responded to Mr. McRae's latest filing. So basically, that's why it wasn't rebutted. So here in number 8, it says, an unrebutted affidavit testimony. That was the unrebutted affidavit submitted by Steve and Steve's lawyer.
Right.
So basically, by leaving it unrebutted and not answering the arguments that you and I went over last time, this supports the finding that there is probable cause.
Yeah. Yeah. This is why, like, you don't just ignore things.
Interesting.
Right?
It's almost, you know who wouldn't make this mistake?
Who's that?
An actual lawyer.
No. No.
It seems to me that Mr. Curtis doesn't have an actual lawyer. It seems to me that this rhetoric towards the beginning of this entire shit show, which started last year, of Mr. Curtis having a lawyer was complete horseshit.
I don't understand why you lie about that. I don't even get that.
I guess to be intimidating?
That or just to drum up support of the people who are supporting him to be like, oh no, yeah, he's going to fight this. Yeah. I guess that's the only thing I can come up with.
Because he said at the very start of this shit show, I have spoken to an attorney. I have spoken to a lawyer. I have a lawyer. My lawyer will get in contact with Steve. We're going through the proper channels. He said this multiple fucking times.
Yeah. I don't understand that. Honestly, I really don't. Like, I spoken to a lawyer is different than I have a lawyer. But if you're saying you have a lawyer, why would you not have a lawyer? If you're saying you have a lawyer.
Now, correct me if I'm wrong, but let's say you were representing me in a case, okay? Mm-hmm. And let's say there is a pending case against me, like I brutally murdered a bunch of people in a pool of their own blood with enough evidence to fill a fucking Mack truck. And that was a case that was being thrown at me. Mm-hmm. It would be in my best interest to get a lawyer to fight on my behalf on that being bullshit. Yes. Would it not be prudent for me to reveal the identity of the person I have representing me to the other party?
Yes.
So why didn't...
You would want to.
So why didn't Mr. Curtis do that? Oh, I know why. Because his supposed lawyer, his supposed attorney, never existed.
I mean, I was saying that from the start, like even the moment, like the first moment, Kyle's like, "Well, I'll get you that later." Like, no, dude, if you have a lawyer, you give them your information now. Mm-hmm. There's very rarely a circumstance in which hiding the name of your attorney is a good idea.
That's what we all said. We're like, oh, I don't want to give the fucking identity of my attorney. Why? What is the logic behind that? Well, we now know the logic behind it is because he was stolen.
Right. Exactly. But there is very, very, very rarely a reason. I can only think of as an attorney, if I'm representing somebody that's trying to bid on some contract or some part of land, and I don't necessarily want the person who's selling it to know who I'm representing right away, like then as the attorney, I may not divulge the name of my client, but I don't understand why you wouldn't, I mean, obviously again, but yeah, it just doesn't make sense for anyone to not divulge the name of their attorney if you are being sued.
That was absolutely epically worded. Good job. That was great. That was good. See, this is why you and I are friends. I also don't give you a choice in the matter, but this is why we're friends.
That's fine.
I just found OPTLawyer on the street, and I was like, ooh, I need this. Mm-hmm. And I just walked away with them.
Yeah, that's pretty much what happened.
That's what happened. Anyway, but for those orders, the court would issue Mr. McRae's request order that Mr. Curtis appear to show cause why he should not be held in civil contempt until he has fully complied with the court's judgment or demonstrated adequate grounds that such judgment must be set aside. So basically, hey, Kyle, what's your argument that this judgment should be set aside? Oh, Wesley was being a meaty head, poopy pants. It's keep going. Proceeds to sharpen axe. You know, that fucking foot powered fucking roto stone. He's just grinding against it with the sparks flying. That would be an awesome sight in court. Oh god, that is what I would do. That is exactly what I would do if I was a judge. Just throwing that out there.
I can only imagine.
Cause why he should not be held in civil contempt until he has fully complied with the court's judgment or demonstrated adequate grounds that such judgment must be set aside. I'm just going to make a prediction right now. Kyle's going to have jack shit to show that the judgment should be set aside. Period.
I mean, that's assuming he shows up.
Yeah, that is assuming he just doesn't make a fucking break for it and go to Mexico. He's gonna be in Mexico City with his new friends. I wonder how their salons are down there. I guess he'll find out. Anyway, in light of the court's inability to proceed in that manner, by this order, the court advises Mr. Curtis that the court's judgment remains in full force and effect, and that while the court makes no final findings of fact or conclusions of law prior to a hearing to be scheduled, if Mr. Curtis in fact has willfully violated and continues to violate the court's judgment during the period in which the court is unable to hold the required hearing before finding him in civil contempt, the court will give appropriate consideration to imposing all permissible sanctions and, if necessary, requiring Mr. Curtis to be imprisoned until he fully complies with the court's order. Mr. McRae, in turn, is advised that the court will respond appropriately if his assertions prove to be without basis, which, by the way, I'm just going to let you guys know Steve has nothing to worry about. 11 is the parties should govern themselves accordingly, and I agree. The parties should govern themselves accordingly. And going back to this, and I want you to comment on this, OPT lawyer. In fact, has willfully violated and continues to violate the court's judgment during the period in which the court is unable to hold the required hearing. Well, we are currently in a period where the court is unable to hold the required hearing, so that means this shit needs to happen now.
Well, yeah. So what the court is basically saying is right now it cannot, because of the circumstances, it can't do anything. So, it's basically saying, yo, I can't do anything right now. If you keep doing what you're doing right now, and then we finally have a hearing come, say, June, whatever, I'm going to take this into consideration, just so you know.
So basically it's like, yo, I have a default judgment against you. It is in your best interest that you fucking follow it. Otherwise, I'm just saying, this axe grinding, I'm getting really good at it.
Yeah.
So, basically, what if you were representing Mr. Curtis? Let's have a lawyer that actually has his head screwed on straight actually speak on this, as if you were representing Kyle Curtis. What?
Okay.
I know. I need you to stop vomiting in your mouth, and I need you to pay attention. What advice would you give to Mr. Curtis right now?
Follow the freaking order. Like, that's about it. Like, at this point, just do what the order says. Straight up.
Follow the order. Follow the fucking order. Now, I did want to point this out, that this document by the judge... Oh, by the way, we're at the very end of the document. So it says, the 13th day of April, 2020. If only it was on a Friday. God, that would have been so juicy. But unfortunately, it's a Monday. But I'll take it. Anyway, this document that we just read does not speak to Kyle's motion to set this whole shit show aside.
Not yet, no.
It basically says that that's still pending. However, we are going to proceed with the default judgment. The default judgment being the court's judgment remains in full force and effect. That's the verbiage that they use. So the court's judgment remains in full force and effect. So we are proceeding with the default judgment in mind. We'll get to everything else later. So we haven't really ruled on whether this shit's going to be set aside or not. But in the meantime, hand over the fucking shit.
Yeah, a court's order is in effect until the court until it's vacated, either by the court itself or the like an appellate court or something along those lines. And the fact of the matter is, what this quote unquote order, I say that because it's not really much of an order, but it basically is telling the parties that, hey, we're going to have hearings on both your motions. In other words, they're going to have a hearing on Kyle's motion and the motion on Steve's show cause hearing. It's probably going to be at the same time.
Yeah.
And that's the court wanted. It feels like the court wanted to just let the parties know that, one, we understand that, like, acknowledge the fact that all this stuff's been filed, acknowledge the fact that we want to have a hearing and we can't do that, and acknowledge the fact that, hey, there's probable cause that Kyle has committed contempt. So, hey, just FYI, here's the things I could do to you if I find you in contempt. And here's what, in my opinion, what this order is doing. It's trying to scare the living daylights out of Kyle to get him to comply, so this whole thing just goes away and they don't have to do anything with it later.
Well, it's not just let me ask if you agree with this. It's not just an attempt to scare Kyle. This is an actual fucking threat. I would read this as a threat. Like, look, dude, we have probable cause. There is going to be a hearing on it. It would be in your best interest. It really would be in your best interest if you follow through with the order. Because if you don't, you can get fucked hard.
As I said, I would call it a warning just because that's the more professional term. But yeah, basically, the judge very, very distinctly let him know, like, hey, this is the thing I can do to you, just FYI.
Well, yeah, because he uses the phrasing full force and effect. So the court advises Mr. Curtis that the court's judgment remains in full force and effect. I mean, how fucking clear can you get?
You can't. Like, that full force and effect is a legal term, and that means something to, like, people like me who went to law school and whatnot. That's a very powerful phrase. That means you're supposed to do this.
And if you don't do it,
bad things.
Bad things happen. So the judge starts sharpening his axe on that stone. And there's sparks flying, and you're going to be there, and you're going to watch him sharpen it.
Absolutely.
And then he's going to be like, okay, out back. And by the way, OPT, I want you to imagine this. Imagine the judge standing up with an axe in hand. Okay. You have that image? And then looks at Kyle and says, all right, out back. And then after he says that, you hear this with the axe.
Yeah.
That's right. That's right, motherfucker.
Boy.
You go, was that a gun shell that just came out of that fucking axe?
Right, yeah, that's
So
the judge is not fooling around. Straight up, the judge is not fooling around in any way, shape, or form, and he's basically telegraphed his current attitude towards what's going on.
Yeah. So now the next step, I guess, is for Steve's lawyer to send Kyle a letter saying, "Hey, hand over them keys," and basically hope that Kyle doesn't have his head wedged so far up his ass that he decides to ignore it.
Chances of that happening?
I don't fucking know.
I would say slim to none, and Slim may be leaving the building. God. Like, this is one of those things, and I understand that not everybody can always afford an attorney. I totally understand that, but there are times when at least speaking to an attorney is a good idea, and having any kind of common sense would help. Things should not have gone this far as like everything. Like, the default happened, you have an order, follow it, or do the thing where you file the motion to get it set aside and have actual evidence instead of just, making crap up.
Well, I know I'm asking a really difficult question here, but what do you think is going through Kyle's mind right now?
I had an immediate answer that's inappropriate for anything, but I honestly don't know. Like, seriously, like, after reading the stuff he filed, I don't know. I legit have no idea what is going on in his, outside of the fact that I'm sure he's just trying to stall.
But he has nowhere else to go. He can't stall any longer without getting seriously fucked over for his stalling.
Yeah, I think we've hit that point in the road, and that's why I'm saying he might comply, but I don't know. He may be of the mindset that he thinks he's going to win his motion somehow, and then be like, fine, let's have this hearing. I'm going. Let's do it. But good luck to him on that.
Yeah, basically, you would not advise it.
I would not advise it. No.
On a scale of 1 to 10, how strongly would you not advise it?
10 to the 10th power.
Ouch. Damn.
It would basically, if I was his attorney, I'd be like, you're either following this order, you're giving me a really flippin' good reason how we can get this order vacated with actual evidence and so on and so forth, or I'm withdrawing from representing you.
Well, I would say, okay, tell me if I am right to think this way. I think you would have to be an absolute fucking dumbass to try and stall any further, because it's clear that Kyle was engaged in gamesmanship. I'm just going to say he was engaged in gamesmanship. The time for that has passed. Congratulations, Kyle. You stalled and stalled and stalled some more, to the point where now there is a hearing tentatively scheduled being set on whether or not you should be held in contempt or not. Congratulations. You successfully pushed this to the point where you've just fucked yourself.
Yeah, I think part of this is, because I think at some point the issue is he's going to have to admit that, like, the money's all gone.
But I would just say congratulations. You've been very successful in the fact that you have stalled to the point of fucking yourself over to where now there is a date scheduled where you're going to have to stand in front of the judge and explain your shit. So congratulations. You've stalled to the point of no return. However, now is not the time to continue that bullshit.
No.
You gotta, fucking hand shit over to Steve. You have to.
Yeah, it's like game's over. Game's over. Just either do it or fess up. Like one of the two. Just do something.
Yeah. So what I've heard is that Steve's lawyer is going to write a letter, I guess a demand letter to Kyle. I'm not sure how it's supposed to work, but I guess that's how it's supposed to work. But you write a demand letter to Kyle, and you just reaffirm what the court has said, and then you say, hand over them keys, along with a picture of a judge sharpening his axe.
I mean, the last part probably not, but yeah. Yeah, it's going to be interesting to see what his lawyer's going to send Kyle. I'm actually curious because technically they don't have to do anything.
Yeah. Let's see. Dim Sum Nimsum for $5 Canadian. By the way, I may have missed a whole shitload of super chats because I wasn't reading the chat, so I apologize for that. And also, I see that Cheshire has put a hit out for my nuts. You and everyone else. So, Dim Sum Nimsum says, is the court using this language because they know Kyle is representing himself? Because a lawyer would know the repercussions.
Yeah, so it's entirely possible that this order is much longer than it would normally be if both parties are represented by attorneys. Simply so it's the court's way, and I know this because I've done this before. It's the court's way of trying to show a pro se, hey, there's a way to do things. here's what happens. Here's how to do things. In this case, it's here's what happens if you don't do things. But there are ways to not give legal advice, but ways to point people in the right direction while still being the neutral court. This is one of those things. The judge has clearly pointed out, hey, there's a bunch of statutes here that is how I can hold you in contempt. Just FYI.
Who was it
That's
that
how
said,
it happens.
Who was it that said, a man who represents himself has a fool for a client?
I don't know, but I've heard that so many times. It's, yeah.
And it holds true in this case?
Mm-hmm.
Mm-hmm.
I wouldn't even represent myself in anything beyond like a moving violation traffic ticket. Like straight up, I would not, because as an attorney, you're too close to the situation. But and again, I know people can't always afford attorneys and whatnot, but there are places to go to get legal advice. And
yeah, I get you. Mr. OPT lawyer, you were charged with speeding. You were doing 150 in a 20-mile-an-hour school zone. What say you? Your Honor, if it is so pleased the court, I must present to you Exhibit A, my Toyota Prius. As you can see, this piece of shit can't even get out of its own way. So how in the actual fuck can I be going 150 when this thing is such a piece of shit that it can barely do 15? I rest my case, good sir. I rest my case.
I love the analogies you come up with.
I have a way with words. What can I say?
Mm-hmm.
It's part of my charm.
Nice. All right. Well, unfortunately, I do actually have to get going.
Nope. Literally, that is the end of the hangout. We are.
There you go.
We are at the end. We are at the end of the hangout right now. So, with that being said, I do want to say thank you so much, guys, for showing up to this after show. Thank you very much, OPT Lawyer, for showing up.
Thanks for having me.
Completely unannounced. I appreciate that.
No problem.
We will go ahead and take this hangout down. I'll re-upload it as its own standalone video. I'll get rid of that snippet where your computer fucking died. And I will re-upload it as its own standalone video. But guys, thank you so much. And OPT, before you go, as a lawyer, you are now speaking directly to Kyle Curtis. Kyle Curtis is right in front of you. Say what you gotta say to him, and we will be out of here.
Just follow the order. Do it now. You can argue over things later. Follow the order now.
And with that, guys, thank you very much for watching. Thank you very much for being here. And with that, have a good night.